I think that, let me probably shorten this. My learned friend relies on three things when he says that the Commission's pleaded case is deficient. Let me deal with each one of them. The pleaded case on the authority of Hartin. Let me just focus on Hartin and forget about Mijo for a second. The first authority that he cites is Eskom versus Soweto City Council, which is a judgment they gave us yesterday. It's reported in 1992, volume 2, SA 703. It's of the old Witwatersrand local division, a judgment of Fleming DJP. Regrettably, it's irrelevant to what we are dealing with here. It is a case about whether a person who institutes proceedings on behalf of a juristic entity has shown authority to bind the juristic entity when instituting proceedings. And there, the deponent it had stated that he was authorized to make this affidavit. And then the argument was that is different from authority to bring the application. And that's a totally different issue. It's the authority to bring proceedings has nothing to do with the authority to enter into collusive agreements in the competition sense. So case number one is irrelevant. Case number two that is referred to is Gralio, which is a competition appeal court case. It's a judgment of Dambuza JA. The relevant part, it's at page 1693 of the authorities bundle. It's in paragraph 12 where there is some relevance. It was an issue about the trial. So the trial, a cartel trial, had run its course, and one of the defenses of the alleged cartelist was that the person who concluded these agreements on my behalf was not authorized. And that is what they dealt with in paragraph 12. The tribunal found that there was no evidence that the respondent had participated in the alleged concerted practice, and further that the appellant had not proved that Hansen had authority to represent the respondent and to agree and bind it in the participation of the cartel activities. The tribunal also found no basis in the evidence from which it could be inferred that Hansen had or would have conveyed the resolutions or agreements concluded at the cartel meetings to those in authority within the respondent. So again, that is irrelevant to the question of pleading authority at exception stage. Then the third one is then Rule 15.2. And the basis for invoking Rule 15.2 is that it says material facts must be pleaded.